State recognized presence of the jury.
We do, Your Honor.
Defense.
Yes.
Ladies and gentlemen, I understand that you've reached a verdict. Is that correct?
Yes, ma'am.
Could you hand that to the deputy, please? Madam Clerk, if you'll publish the verdict.
In the Circuit Court of the Ninth Judicial Circuit and in Fort Orange County, Florida, case number 2014 CF 14049, the State of Florida versus Juan Rosario. Verdict as to count one. We, the jury, find as follows as to count one of the charge. The defendant is guilty of murder in the first degree as charged in the indictment. Verdict as to count two. We, the jury, find as follows as to count two of the charge. The defendant is guilty of arson of an occupied structure as charged in the indictment. So safety elevated, this 26th day of April 2017, both forms have been signed by the court.
I decide which the jury polled.
Yes, please.
All right. You may poll the jury.
Starting from the back. Juror 240, are these your true and correct verdicts? Juror number 695, are these your true and correct verdicts?
Yes.
Juror number 983, are these your true and correct verdicts?
Yes.
Juror number 308, are these your true and correct verdicts?
Yes.
Juror number 718, are these your true and correct verdicts?
Yes.
Juror number 399, are these your true and correct verdicts?
Yes.
Juror number 492, are these your true and correct verdicts?
Yes.
Juror number 332, are these your true and correct verdicts?
Yes.
Juror number 415, are these your true and correct verdicts?
Yes.
Juror number 434, are these your true and correct verdicts?
Yes.
Juror number 447, are these your true and correct verdicts?
Yes.
Juror number 790, are these your true and correct verdicts?
Yes.
The jury is unanimous. Ladies and gentlemen, this is the point at which I normally discharge you from jury duty, but because Mr. Rosario has been found guilty of murder in the first degree, as we explained to you during jury selection, there is a second phase to this trial, and that will be the sentencing phase. So you are not discharged as jurors in this case, which means you remain bound by the rules you've had so far. No watching TV, no internet, no looking, talking to anybody about the case. You will be surprised at the number of people who will attempt to talk to you about this case and more specifically attempt to give you an opinion about the sentencing in this case. You are not allowed to talk to anyone. If they approach you, you are to tell them that you cannot discuss anything with them, and furthermore, you cannot hear any opinions from them about anything that has occurred up to now or in the future in this case. Do you all have any questions about the instruction I've just given you? All right. You will need to return for the sentencing phase in this case. Preliminarily, how many jurors are available the week of May 29th? Just raise your hands. All right, so everybody appears to be. How about the week of June 5th? Is there anybody who has a problem with June 5th? You have a problem with June 5th, so I have 2 jurors. All right. We will set, so everybody's available on the week of the 29th, so I will probably set the sentencing for that week. We're going to give you a piece of paper with a phone number that you can call after May 5th. It will give you the exact date and time. You will report back to this courtroom the same as you've been reporting for jury duty. In the back, the deputies will instruct you on all of that. And between now and then, please don't talk about this case with anyone, and don't let anybody talk to you about the case. Any further instructions requested by the state?
Remind me not to read about it.
Oh, if I didn't say that, no reading about it, okay? Just, I'm sorry?
Nothing further.
All right. Mr. Whedon, any further instructions requested by defense? All right, ladies and gentlemen, you're free to go for this evening. Gentleman, sorry. It's just a habit. You're free to go for this evening. Thank you very much for your time and attention so far. We will see you back here sometime the week of May 29th. If there's a change, you will hear about it on the recorded information. Have a good evening. Your excuse for tonight.
Jury's exiting.
Yeah, let's go ahead and get numbers filled. Mr. Rosario, a jury having found you guilty of murder in the first degree and arson of an occupied structure, at this time the court adjudicates you to be guilty of both counts and directs that you be fingerprinted here in open court. All right, while they are fingerprinting Mr. Rosario, is there anybody in the defense team who is not available the week of May 29th?
That's fine with me, Judge.
Mr. Whedon? I know Mr. Davila is going to take the lead on mitigation, is that correct?
Yes. And obviously, wherever I have
State, any issues with that 29th? It's the one time we have all the jurors available, so, all
No, I don't believe there's an issue.
right, I'll figure it out and make it work. Can you guys give me an idea of how long mitigation, the penalty phase is going to take? Defense?
It will probably take the day, Judge.
Okay, 1 day for the defense?
I believe so.
State, how much do you perceive yours taking?
Probably no more than a day, Raj.
All right, so if I schedule this for 2 days, we're fine. Is that
Should be.
correct?
I believe
The
so.
29th is actually Memorial Day, I think, or is it the week before? It is, the 29th is Memorial Day. Right, so the earliest we would start would be that Tuesday. I'm going to take a look at my schedule. And I'll let you know the exact start time. Yeah, the 30th is the day I'm actually looking at, which is the start of a trial period for me, so I know that we're clear that week. So, absent me telling you something different, we will begin penalty phase in this courtroom May 30th at 9 a.m. I have here an order on the state's motion for appointment of expert. It was an Ora Tennis motion. Have you filed the?
I need to file a motion up before.
All right,
All right, approach the clerk.
you may. Mr. Davila, Mr. Whedon, would you like to look at the order I'm entering? It appoints. Yeah, before I sign it. I'm sorry?
I have an extra.
Actually, yes, please, because I want to. All right, I'm granting the state's motion for an appointment of expert. Obviously, the expert is to examine Mr. Rosario after the defense's expert has completed their examination.
My understanding, the expert examination is going to be May the 1st.
The deposition, well, the examination, hopefully, Your Honor, I'm going to contact him tomorrow,
Okay.
firm everything up.
There are matters I need to address at this time about penalty phase.
We are anticipating, our hope is to have our expert see Mr. Rosario on May the 4th.
Okay?
I don't know if it would be appropriate for the court to instruct Mr. Rosario directly at this time about the need to cooperate with the expert chosen by the state and the consequences of failure to do so.
I'll go over that with him when the deputies are done.
Well, Your Honor, there's just one matter. The previous attorney who was doing the mitigation filed a motion.
All right, I can understand that he needs a break. We'll schedule this. Are you waiving his presence for what you're about to say, Mr. Davila? You, Mr. Whedon?
Yeah, it's just-
Mr. Rosario, you have a right to stay here. We're going to discuss some of the penalty phase issues. I'm sorry? All right, you're waiving your right to be present for this? All right, sir. He's excused from the courtroom. We'll have a separate hearing. I'll go ahead and discuss it with you, but we'll discuss it again in front of him when he's on a different day. Go ahead, Mr. Rosario.
Yes, the previous attorney had filed a motion on the victim impact that would be videotaped or at least in writing rather than live testimony, Judge.
I saw that.
There are reasons why, and based on what we saw, we can argue it later on. There's some case law that he provided.
I've seen that there were some motions filed that have never been called up for hearing. There's a motion to videotape victim impact testimony if it occurs in front of the jury, or in the alternative to direct that all victim impact testimony be in writing. I anticipate that you all will need some hearing time between now and the 30th, or you might. If you'll just get with my judicial assistant and coordinate with the state, I don't know if you're filing any motions. I know the defense has filed some motions that are related to penalty phase that have never been heard. I don't know that they weren't filed by you, Mr. Davila. They were filed by the previous
That's correct.
mitigation attorney. So
We thought they had all been ruled on, Judge. I may be wrong.
I don't see an order in the file.
Okay.
And Judge Higbee, who is the only other judge that's heard this, correct? Or was there another judge that heard these?
She's the only one who did it in substantive motions, yes.
Judge Higbee handed me the entire notebook containing all of everything she had ruled on, and I did not see any orders entered by her on those motions. If I'm wrong, just let me know, but the court file's not showing, and it's just possible I missed them, but I'll look again.
Well, Judge, I can get together with the state and we can go over and see.
At this point, has the state gotten all of the mitigation evidence that the defense has and intends to
Yes.
rely on?
Yes.
Okay, and the witness list, you all told me the depots are going to be starting?
Depots are starting Monday afternoon, May the 1st, and we have received a rather thin packet of information, some minimal school records from the state of New York, and what appear to be medical records from the Orange County Jail. I would ask, just to bring this up now while we're here, I do intend to ask Mr. Davila or Mr. Whedon to have Mr. Rosario execute a release of medical records to the Department of Corrections so that we can obtain whatever medical records and psych records they may have on him.
Mr. Davila, do you anticipate that being a problem?
It wasn't before today, Judge.
Okay,
I'll go speak with him and hopefully we'll be able to resolve that.
all right.
Of course, they would get copies of them too.
I understand. I'll give you guys a couple of days. I'll be here Friday in the courtroom all day. Monday I have trials, but if you need anything, just let me know, and I'll work you all in somewhere. I mean, it's a short schedule to get all this done, but we'll get it done and get it worked out between now and then. Anything else we need to address?
No, Your Honor.
No?
Thank you,
I'm
Judge.
going to file some motions related to Friend Day and reference to the aggravating factors not being but we'll get that point.
Like I said, I anticipated that we would need some motion time. If I were you all, I would call Trina or email Trina tomorrow and start getting some time reserved for hearing, just reserve some hearing time. I've cleared the procedure where normally you have to file the motion first and then reserve the time. You can go ahead and reserve the time, give her a good faith estimate, and then get the motions filed. You will need to file all of your motions at least 5 days before the hearing date so that the state has time to go through them, and you have to provide copies to them at least 5 days before the hearing date so they have time to prepare if necessary. Are any of these motions, do you anticipate any of them requiring witnesses, or these are all going to be legal motions?
Mine would be legal motion.
Mr. Davila, do you anticipate any of yours requiring witnesses?
No, ma'am.
Okay.
And because of the reason, there's been some petitions down south, like Palm Beach and all, and because of some of those rulings, if you want to look at those things, and you can, and I'll send an order for some of those issues, and if you decide it's not necessary to have a hearing, because of precedent, I won't be offended if you enter an order based on leadings.
That's fine. Just as long as you know, I communicate by email very well, so if everyone will just send me what they want to send me. Make sure you copy me with any motions in case law. You can just give me a list of the cases. You don't have to attach a copy of the case.
Okay.
That you're relying on so that I can be ready to go on all of these motions, and then just make arrangements with Trina to get some hearing time set aside.
Sure.
Please do not set the hearings prior to May 8th of this year. Okay? All right, anything else? Court's in recess. Everyone have a good evening.